If you've ever called your insurance company after a denied claim to ask why, to argue, to plead your case, you may have already made the move that cost people their right to sue. Not because you said anything wrong, because you said it out loud instead of putting it in writing. And insurance law, that difference can close a courthouse door permanently. Before this video is over, you'll know exactly why that happens, what the internal grievance process actually is, and how to use it to force an insurer to reverse a denial or set yourself up to win in court if they don't. This is for educational purposes only and is not legal advice. But the rules we're about to walk through are real, they're named, and your insurance company already knows every single one of them. Here's the thing most policyholders don't realize. A denied claim is not the end of the process. It's actually the beginning of a legally structured process, one with specific steps, specific deadlines, and specific rules that you have to follow in the right order. Skip a step, do one of them verbally instead of in writing, or miss a deadline by a single day, and the insurer's lawyers will argue you waived your rights. And in many cases, courts agree with them. So, what is that process? It's called the internal grievance and appeal process. And almost every health, disability, and life insurance policy in America is required to have one. The Affordable Care Act, specifically Section 2719, mandates it for most employer-sponsored and individual health plans. ERISA, the Employee Retirement Income Security Act, mandates it for employer benefit plans, and the vast majority of state insurance codes require it for everything else. The trick, the one that changes everything, is understanding that completing this process correctly is not just a formality. It is a legal prerequisite. You generally cannot sue an insurer in federal court under ERISA until you have exhausted your internal remedies. That's the doctrine! Exhaustion of internal remedies. And it means that if you skip the formal appeal and go straight to a lawyer, a judge can dismiss your case before it starts. Now here's where the system is designed to work against you. When your claim gets denied, the insurer sends you a letter. That letter has an explanation. It sounds final. It uses language like not medically necessary or excluded under your policy or failure to obtain prior authorization. And at the bottom, in small print, there is usually a paragraph about your right to appeal. Most people read that paragraph and do one of two things. They call the number listed, or they ignore it entirely. Both of those are exactly what the insurer is hoping for. Because here's what's actually happening on the other end of that phone call. The insurer is not recording that conversation to help you. They're recording it to protect themselves. Every verbal statement you make, every concession, every I understand, but is potentially usable. More importantly, a phone call creates no paper trail for you. You have no proof of what was said, no proof of what was promised, no written record that you formally disputed the denial within the required window. Under ERISA, you have 180 days from the date of the denial to file a formal internal appeal. That is the federal minimum. Some plans are shorter. Some states have tighter windows for non-ERISA plans. 180 days sounds like a long time. It is not, especially if you've spent 60 of them making phone calls that reset nothing. And here's where it gets interesting, because the way you respond to that denial letter in the next few days is actually the most important legal move you'll make in this entire fight. So what does the internal grievance trick actually look like in practice? It starts with one rule, everything in writings. Every single communication from this point forward goes on paper or in a trackable digital format, certified mail, email with read receipts, or a secure portal with timestamps. Your appeal letter needs to do 4 specific things. 1. It needs to formally state that you are invoking your right to an internal appeal under your plan's grievance procedures. Name the process. Use the word appeal or grievance explicitly. 2, it needs to reference the denial by date, claim number, and the stated reason for denial. 3, it needs to include or request any clinical or policy evidence that contradicts the denial reason. If denial was not medically necessary, you want your doctor's letter, the clinical guidelines they used, and a direct rebuttal. 4, it needs to request in writing a complete copy of your claim file and the specific plan documents they relied on to deny you. Under ERISA, they are legally required to provide those documents. If they don't, that failure alone can be used against them. Which of those 4 steps have you seen left out of the advice you've gotten before? Tell me in the comments, because what we're about to get into next, the external review process, is where the real leverage lives. Now the insurer has a deadline to respond to your internal appeal. Under ACA rules for urgent care claims, that's 72 hours. For standard claims, it's 30 days. For retrospective claims, 60 days. Those deadlines are federal minimums. If they miss their own deadline, that is a violation, and it strengthens your position for the next step. But here's the part nobody talks about. Even if the internal appeal comes back denied again, you haven't lost. You just unlocked the next level. And this one has real teeth. External review. This is the process that insurers genuinely do not want you to know about. Under the Affordable Care Act and the NAIC Uniform Health Carrier External Review Model Act, which most states have adopted, you have the right to request an independent external review of a denied claim after completing the internal appeal. An independent organization, not affiliated with your insurer, reviews the denial. And here is the number that matters. Studies cited by the Kaiser Family Foundation found that consumers win external reviews roughly 40 to 50% of the time. 40 to 50% on claims the insurer already denied twice. That is the real leverage. An independent reviewer with no financial relationship to your insurer, no incentive to protect the denial, reads your file and decides. And their decision is not a suggestion. To request external review, you typically have 4 months from the date of your final internal denial. Under federal rules, you file the request with your insurer or directly with your state insurance commissioner, depending on your state's process. The reviewer's decision is legally binding on the insurer. Not a suggestion. Binding. And filing a complaint with your state insurance commissioner simultaneously is not just cathartic. It creates a public regulatory record. Insurers track their complaint ratios with state regulators. A high complaint ratio can trigger audits. The Consumer Financial Protection Bureau and state insurance departments publish these records. Use them. Here's what that means in plain terms. You completed the internal appeal, which satisfied the exhaustion doctrine. You filed for external review, which means an independent body now reviews the denial and their ruling locks the insurer in. You filed a state commissioner complaint, which puts the insurer on a public regulatory record. And you've done every single step in writing, which means you have a paper trail that holds up. That is not a loophole. That is the full process working exactly the way the law intended it to work. And the insurer knew every step of it. Now you do too. If these are the mechanics you've been missing, the leverage points insurers count on you never finding, that's exactly what this channel breaks down every week. Subscribe! We expose what insurance companies hide in plain English every single week. Now let's talk about what kills otherwise valid appeals. Because it's not usually the facts of the case. It's procedural mistakes that happen before the insurer even evaluates the merits. Mistake 1, missing the proof of loss deadline. Almost every insurance policy has a clause, usually called the proof of loss provision, that requires you to submit documentation of your claim within a specific window after the loss occurs. Under many standard policies based on ISO standard forms, that window is 90 days. Miss it, and the insurer can deny the claim outright on procedural grounds, not even on the merits. People lose winnable cases because they waited to gather all the documents before submitting anything. The fix: file a placeholder claim in writing immediately, then supplement with documentation. Get the claim date on record first. Mistake 2, accepting a partial payment without a reservation of rights letter. When an insurer sends you a partial settlement check, sometimes that check has language on it or in the accompanying letter that says something like full and final settlement of this claim. Cashing that check, in many states, can legally constitute acceptance of that amount as full resolution, even if you didn't read the fine print. If you receive a partial payment and you intend to dispute the full amount, write a letter before or when cashing the check, stating explicitly that you are not accepting the payment as full and final settlement, and that you reserve all rights to pursue the full amount. Some people in this situation send that letter certified mail and keep a copy with their claim file. That letter matters. Before the last mistake, I want to ask you something directly. What's been the biggest insurance or consumer rights issue you've run into? Leave it in the comments below. Your situation might be the next video on this channel. Mistake 3, and this is the one that waives the right to sue entirely. Waiting past the limitations period in your policy. This is different from the statute of limitations in your state. Most insurance policies contain their own internal limitations clause, sometimes called suit against us or legal action against us, buried deep in the policy. This clause sets a deadline, typically 1 to 3 years from the date of loss or the date of denial, after which you cannot bring a lawsuit against the insurer under any circumstances. Courts enforce these clauses. In the Landmark case of Hymashaw versus Hartford Life and Accident Insurance Company, decided by the Supreme Court in 2013, the court upheld that contractual limitations periods in ERISA plans are enforceable, even when they're shorter than the state's general statute of limitations. That's a real Supreme Court case, and it means the clock in your policy, not the clock in your state's laws, is the one that controls. If you've had a denial sitting on a desk for 18 months and you haven't filed the internal appeal or the external review, go check your policy's suit against us clause tonight, because that clock may already be running. Now, here's what this all comes down to. A denied claim is not a verdict. It's a first move by an institution that profits when you accept it and walk away. The internal grievance process, the external review, the written paper trail, the state commissioner complaint, these aren't loopholes. They're the process you were always entitled to. The system just made them invisible. The insurers know every deadline in your policy. Now you do too. And here's the move that ties it all together. The internal appeal satisfies the exhaustion doctrine, so you keep your right to sue. The external review gives you a binding independent ruling before you ever need a courtroom. And everything in writing means the insurer can't rewrite the story later. That sequence, in that order, is how you don't accidentally waive anything. There's a video already up on this channel about the cooperation clause, the policy provision insurers use to demand recorded statements, and how complying the wrong way hands them the evidence to deny your claim permanently. That's the next piece of this puzzle. It connects directly to everything we covered today. And if your own situation, a denial, a deadline question, a clause you can't make sense of, hasn't shown up on this channel yet, drop it in the comments. That's exactly how we decide what to cover next.